I cannot share my screen. So we're just going to proceed with tonight's webinar, and I could send out my slides later on, but for some reason Zoom and my system security preferences will not let me share my screen. So we're going to jump in and I guess just take some notes as you go along. But I have this wonderful PowerPoint that I was hoping to share. So this is being recorded. This is our last webinar of the winter series. And I am happy for everyone that's hung in with us through the whole thing. And I thank you for that. Everyone is muted, but you can certainly put questions in the chat box. We'll have time later on to go over questions. And I just wanted to give a disclaimer that everything here tonight is not to be taken as legal advice. It is just for informational purposes only. So of course, anytime you have a legal matter, you should be consulting with an attorney for your particular circumstances. And tonight we're going to talk about what to do when a loved one dies. So it's a very hard process to go through and grieve and deal with all the emotions that come from dealing with when a loved one dies. But not only on top of that do we have to deal with the emotional aspect, we also have to deal with all of the legal stuff that comes along with that. What to do with all of the assets and make sure all the debts are paid and the funeral arrangements are paid for. How do we handle all of that? So that's what we're going to talk about tonight. And tonight's topic, we'll talk about what's the first things that need to be done after a loved one dies. What are those immediate things like final arrangements? And then we'll talk about the actual probate process and what to do. What does probate entail and what do we have to do during that? I have a guest with me tonight. You're not going to see her on the screen, but it's my toddler. So she is here with us. So let's jump into the first thing, is who's in charge after someone dies? A lot of times there's a lot of confusion about that. Who's going to handle all of the arrangements? What do we do? Do we look to the guardian if the person had a guardian appointed? Or do we look to the power of attorney? And that's a big question mark that often people encounter. And the truth is that when someone passes away, their power of attorney actually does not have the power to act anymore. The power of attorney dies when a person dies. So that person has no more power to handle their finances, talk to the banks, talk to mortgage companies. So they're pretty much, that role is useless. Guardians, they also no longer have the power to act because they were the guardian of the person. And once they've passed away, there's nothing to act for anymore. Sometimes the only thing a guardian has to do is prepare a final accounting to the court, but other than that, there's nothing left for them to do. So then who's in charge? If there is an executor or an administrator, while they don't have the legal authority to act, if someone has appointed an executor in their will, that person can help with all the decisions that need to be made. So it's something that someone needs to step up and start making decisions, maybe start notifying banks or Social Security. The executor is the person that can step in and start doing that. Who do I notify? That's another great topic, another great question that I get a lot is, who are all the people that I need to tell that my loved one has passed away? And normally, some of it may be obvious. We need to tell close family and friends. If the person is still working, obviously you tell their employer. But also you need to tell Social Security because we get paid 1 month ahead of time. You might owe a month of payment, depending on when the person passed away. You need to tell the funeral home. And also the tax authorities, the IRS, and depending on the state where the person was a resident of, you may have to tell that state's Department of Taxation that they passed away. Also, if they're getting a pension or retirement, if they have a 401k, you're going to want to notify them because there's beneficiaries on those accounts that they need to notify them to start getting the distribution process going. And also for retirement accounts, depending on when they died and when they have to take their required minimum distributions, it's a good thing to notify those companies so they can tell you if there's any RMDs to take. Otherwise, if they're not taken, then you could get a penalty. And it's a pretty hefty penalty if you don't take your required minimum distributions. You also want to let the banks and any insurance companies or other financial institutions know that this person passed away. A lot of times what they'll do is put freezes on the accounts, and that's to prevent any fraud. You want to make sure that there's no fraudulent activity, no deposits, no withdrawals going out that haven't been authorized. Or no one else accessing the money. Same thing with credit card companies, utility companies, the Department of Motor Vehicles, and then of course their accountant and financial advisor if they have one. That's also very important because there's taxes involved after tax filings that need to be done. Financial advisors that manage investment accounts, they need to know this. So it's very important that you tell all the people that are involved. You also want to make sure that you are able to protect the decedent's property. So that means that if they own a home, is that home secured? And that means, is the security system on? Is the heat being maintained? If it's the winter time and it's vacant, maybe you want to think about, is the house winterized? Are the windows locked? Have I forwarded the mail from the decedent to someone who's going to be gathering it and going through it and seeing that if there's any bills that are in there that need to be addressed? Also, you want to go through and do a quick inventory of all personal property, including cash and valuables on hand that you find, just in case before any family members start removing items, start divvying them up. It's really important to do a quick inventory of these items. And like I said, you want to place a hold on credit cards and bank accounts. That's a really important immediate step to take. And then pets, if there's any pets, you want to make sure. Sometimes people have made arrangements for their pets already. A lot of times they don't. It's something that's easily overlooked. So if there is a pet and there is a caregiver that's been named, you want to make sure that we're getting the pet to the caretaker. And if there isn't one involved, then that's just an extra step to figure out, who does this pet go to? Who's going to take care of it until something more final has been figured out? And speaking of final, there's the final arrangements. So that can take many different forms. But two things that outline kind of how to handle these situations. Sometimes a person will have drafted what's called a disposition of remains. And that basically is a form where a person can appoint an agent and give them special instructions on how to handle their final arrangements. So I could, draft a document saying that I'm giving my daughter the power to make my final arrangements, and here are all the specific things I want her to do for me. I want to be cremated, and I want my remains on, I want her to keep it on her mantle forever and then maybe hand me off to her brother and sister every 5 years. Like, if you wanted something specific like that, or you want a funeral service and you want specific songs played, you can put that in there too. So that's what that form is. And if someone has that, that's going to dictate what they like to do. And a lot of times people also have prepaid funeral arrangements. So that's where they have made all their plans ahead of time. They have paid for it. And then all you have to do is just go to the funeral home and see that all the other details are coordinated, like the date, the time, and then everyone just basically shows up. And that takes a lot of the burden off the family members to have to grieve someone's loss and figure out how to coordinate all those details. And then the other problem that comes up often if there isn't prepaid funeral expenses is, who's going to pay for this funeral if something hasn't been put in place already? And sometimes family members have to pitch in and pay for it, but they know that they can get reimbursed from the estate. Funeral expenses have like first priority for payback on monies from the estate, because we want to incentivize people to cover these expenses if when the unexpected happens and there hasn't been money allotted for a funeral already. Another thing that's really important to do after you've made the final arrangements, after everything's been put to rest, literally, in that sense, then it's time to start gathering documents, because you might have to go through the probate process, which we'll talk about soon. Or there might be something else like a trust in place, where you don't have to necessarily go through a probate process, but there definitely is some administrative work that needs to be done. And the only way you're going to know about that is by looking for these documents. So, best case scenario is that someone is highly organized, they have all their estate planning documents together, they're located in one place, and all you got to do is pick it up, open it up, read through it, and you'll know what to do. That's best case scenario, and that's probably happens like 5% of the time. So generally what happens is family members are often searching for documents, searching for clues as to what assets people have if they're not easily known about, searching for documents like wills or trusts or deeds or bank statements to figure out what all is out there, what do we have to find, and what assets do we have to deal with. So there's general places that I recommend that people look for these documents. One is in the person's home. So looking through their safe and their filing cabinets, just looking in all the places that they would store documents. And another place is figuring out if they had a safe deposit box. Now, I don't love safe deposit boxes because you can't get access to them. If you don't name another person on the safe deposit box, then you're the only person that has access to it. And once you pass away, it's not so simple to get access to the safe deposit box. Another place to look is, that's my daughter, sorry. Another place to look is if you know they had an attorney. Contact the attorney's office, because many times, attorneys may keep original copies of the will. They may know the decedent's assets. They may be able to give you a whole lot of information that you would not be able to find in your own search. So checking with the attorney is also a great idea. I know a lot of attorneys have will safes. I will hold wills for clients if they need them held for safekeeping. Another place too that I'm thinking of is sometimes people file their wills with the court for safekeeping. So that's another place to look. If you cannot locate a will, it might be on file with the court, and that's why we can't find it. So that's another place to check. And also any of the fiduciaries that someone would have named as executor, as power of attorney. A lot of times I have clients that say, hey, I'm going to name my daughter as my executor. And then after we draft her will, the client may say, hey, I want to give a copy to my daughter just so she has it. So sometimes we can't locate the original, but then we could probate a copy. And sometimes that happens because that may be the only copy that we have of the document. So that could be a good place to check. Now, besides estate planning documents, there's other documents that you want to collect. So not just the will, that usually is the most important, but there's other things that you want to look for, like a trust agreement, tax returns, deeds, bank statements, insurance policies, retirement plan information. Definitely the death certificate. You're always going to need a few of those on hand. I recommend to clients that they get a few, maybe 5 to 10. You're going to need a copy of the funeral bill and all the receipts for that, and any other outstanding bills that the decedent may owe. Because when you go to probate, you're going to have to figure out not only all the assets that are out there, but what are the expenses that are owed. So once you have all of this information, now you're able to go through it and start to figure out, what is my next plan of action? So normally what people do is once they have all this information, they'll call the attorney. They'll call the estate attorney and say, hey, so-and-so died. I have all this stuff. I have no clue what to do with it. Help me out here. Tell me what I have to do next. So that's normally when a lot of times, if someone doesn't have a trust, a lot of times then we have to start the probate process. Now, the probate process can be a long drawn out process. It can be very overwhelming. So having to go to an attorney for help is a very common practice because it is a court proceeding and there's a lot of formalities with it and a lot of different steps that if you're not really familiar with this kind of stuff, then the chances of you being able to navigate it 100% by your own is it's not very likely. Um, so what is probate? When do I have to probate? Is it required? And the answer is not always. Probate is basically a court process by which you're bringing a will to the court to prove that it is the decedent's original will, and you will use that document to then divide or distribute their assets to the people that they've named in their will. Now, that's a probate process. Sometimes people die without a will, and that's very common. And in that case, it's not called a probate, it's actually called an administration. And the state already has laws that outline who gets your belongings once you pass away. If you don't have a will, they'll give a statutory outline of who gets your stuff. So if you are married, your spouse and your children will split it. If you don't have a spouse, your children will split it. And then it just goes down the line. So, hi, you can sit in my lap. All right. Someone's very tired today. So the laws will, like I said, in an administration, the laws will dictate who will get your belongings. So if it's not your children, it's your, it could be your parents, your siblings, they'll go on and on down the line. So probate, again, is the process by which you will bring your will to the court and file it with the court to give it legal effect. And so you will essentially, the first thing you do is you will submit a probate petition to the court. And basically that will outline all the details that they need to know about the decedent, the will, who's being named as the executor, who are the beneficiaries. And so that's what you need to get the process started. So in the probate process, I'm getting a question. Hold on, let's see. What if you don't have a will and no children? So in the statute, it says if you don't have a will, you would file an estate administration. And if you have no children, but you have a spouse, the spouse will get your share. If you have no spouse, you have no children, your siblings will get it. And the statute will actually outline more and more and more remote descendants that you can go down the line to find a family member. And sometimes that happens when someone dies, they're not married, they have no kids, they really don't have much family left. Sometimes you actually have to hire a genealogical research firm to actually find family members and find descendants that can inherit someone's assets. It's actually, while it's very expensive, it's very interesting. And I'm finding all these other questions here on my screen. Are attorney's fees paid, reimbursed by the estate? Yes, that is correct. And can you clarify probate versus administration? So probate is the process that how you distribute someone's assets in an estate when they have a will. So that's a probate process. So you're taking the will to the court, and the will is going to dictate who gets all of my stuff after I pass away. And then I'm going to take that to the court with my probate petition, and I'll start the process to get everything distributed. And we're going to talk more about that in a few minutes. An estate administration is what that same process is called when you don't have a will. So I will just use New York state laws. If I'm in New York, if I die in New York State, instead of having a will, the New York state law is going to say who's going to get my stuff when I pass away. So the big difference is either you have a will or you don't have a will. That's going to dictate what process do we start with. I hope that answered your question. What if the value of a estate doesn't cover the deceit? cover, what if the value of the estate doesn't cover the decedent's bills? And sometimes estates are insolvent, there isn't enough money, and that's normal. The creditors aren't going to get paid. It just, that happens sometimes. There's just more expenses, or people die, they don't have a lot of money, then they're not going to get paid. Let's see, here's my PowerPoint. Okay, so also, sometimes if people have a small estate under $50,000, you can do what's called a small estate administration. And that is actually, New York State has a DIY process for that online. So a lot of times people will do a DIY estate administration if someone just has a small estate under $50,000. It is fairly straightforward, but I wouldn't really recommend trying a full probate as a DIY, again, because there's a lot of intricacies and nuances. There's a lot of notices that have to go out. There's a lot of rules that you have to know as you go through this process. But the small estate administration is a great thing to use for people that don't have many assets. And sometimes it's just simple and straightforward as, I have a bank account that I just need to file probate for. It's a pain, but it's very easy to go through. So what property is part of the probate process? Not everything is a probate asset, actually. So as probate assets are assets that are in the decedent's name. So maybe they own a house. Maybe they have a bank account with just their name on it. Those are probate assets. There are assets that are non-probate assets. So these are jointly held property, property with two people's names on it. So maybe you have a bank account with, maybe I have a bank account with my mom and both of our names are on it. And when she passes away, or if I pass away first, she will, or I will inherit the rest of that bank account. Assets with beneficiary designation forms are also another non-probate asset. And those are assets that pass just by using the beneficiary that's been designated on the account. So you don't have to probate those. They pass automatically by law. And those usually take the form of insurance policies, 401ks, retirement accounts. They have beneficiary forms on them. Sometimes investment accounts do, a lot of bank accounts too. So these are great things to use because you don't have to go through probate, and they pass to a beneficiary very easily. Well, I should say easier than if you had to go through probate. Another non-probate asset is property held in a trust. A lot of times people have trust these days, and the trust is really technically the owner of those assets. So that even though the decedent, the person who died, may be getting the benefit of that asset, legally the trust owns it, and the trust is going to dictate who gets it later on after the person passes away. So you don't need to probate an asset that's held in trust. So that's why I love trust. I love using trust because it circumvents an entire probate process, which can be very difficult. So what is the probate process? Where do we start? Most people, like I said, go to an attorney first. They'll consult with the attorney who will prepare the probate petition. And then that's when you have to take the original will and you will file it in the county where the decedent, the person who died, was domiciled or living, where they were a resident at the time of their death. And you have to serve notices to all the required parties. So often that is the people named in the will, or that's also anyone that's an heir of the person who died. So if someone died and they had a spouse and 5 children, then those are the people that are going to get the notices advising them that there's a probate going on. And they could consent to the probate and say, hey, we're okay with this, and they'll sign the waivers and probate will proceed. And we'll talk in a few minutes about what happens when they don't consent to probate. Another document that's also required all the time almost is a family tree affidavit. And that's a pretty interesting document. It's actually, it's an affidavit completed by someone who's not a family member. And they're basically attesting to all of the people that are in the person's family that, you know, I know that this person had a wife or had children, or I know about their parents. They're basically attesting to the family tree. And that's often required. And like I mentioned before, sometimes you have to hire an outside company to do research to figure out who are the family members that are out there. Let's see where we are. I wish I could share my really nice PowerPoint with you guys tonight. So another big question that pops up in probate, part of what the process is centered on is the will valid? That's something that we talk about a lot. And it's, you know, that's why execution of your will is so very important, because if you have an invalid will, it's almost like you don't have one, and you have to rely on the intestacy laws of New York that dictate who get your own who get your assets. Someone's saying, I wish you could share your PowerPoint too. I can send it out. My email, I will share my email in the chat. Actually, I'll share it right now, and you can email me and I will share my PowerPoint with you, because it was a really good one. Let's see, I will send it to all of our attendees. There you go. That's my email. You could shoot me an email for the PowerPoint. All right, so someone just asked, what if I'm named as executor and just can't deal with this? That's why you hire an attorney. And that happens all the time. Probate can almost become like a full-time job sometimes. It depends on the amount of beneficiaries that you have in an estate, the amount of assets, the type of assets. What if someone's contesting this estate? It can become like a full-time job, which is why people hire attorneys to do this, because it's just so complicated. So that's actually a really good question. A lot of people don't ever want to deal with this, and I don't blame you, because it just can be a very tedious process with a lot of headaches. So again, let's get back to, is my will valid? That's something that you need to put forward a valid will. And one of the things that we look at when we are putting forth a will is, was it executed validly? That's the execution of your will is so important. And it makes or breaks whether it is actually valid or not. So what's required to have a valid will? Well, the first thing is that the testator, that's the person making the will, they have to have capacity. And so a lot of times I say capacity and no one really knows what it means. And it's a weird concept to try to explain sometimes, but it really, all it is the ability of the person who's making the will, their ability to know what they're signing, have a basic understanding of its terms. So like understanding what's in their will. They have to know their immediate family and have a general understanding of their assets. And capacity becomes really important when we're dealing with people as they age, because as we know, sometimes people have illnesses like dementia or Alzheimer's that affect their capacity, or even just if they're taking certain medicines, or often when people have UTIs, that makes them have symptoms that appear like they have dementia, and they don't appear as though they have the capacity to sign a will. So it's very important that someone have capacity at the time of signing. And when you have illnesses like dementia, lucid moments are very important, because sometimes capacity comes and goes. Maybe if I have dementia and I'm sundowning, that means that I am having a very tough time at the end of my day. But if you caught me in the morning, I probably know everything that's going on and would be able to sign a will very easily and understand what it was. So that's why it's important to make sure when we're dealing with someone who has a challenge like that, to know that at the very hour that they're signing the will, they have capacity to sign. A will also requires at least 2 witnesses that are over the age of 18, and none of them can be interested. If you are an interested witness, you don't count as a witness. And what is an interested witness? That is someone that is getting a beneficial, they're getting a benefit from the will. So someone that you're leaving a gift to, leaving money to, that's someone who is interested. So we want to make sure that if they are signing as a witness, that we have 3 witnesses then, or maybe 4 if we have 2 interested witnesses signing. I don't, as a best practice, I generally don't have interested people sign because it just like doesn't count. Also, you can't have any handwritten changes or additions in your will. Those aren't going to count. Also, one very important thing that I always tell my clients is when your will signing has been supervised by your attorney, you actually get the presumption that it has been that it has due execution, that it's been validly executed, and that's very important later on when the will has to go to probate. So it's actually in someone's best interest. I know a lot of people want to do it yourself Zoom wills and get them online because they're very cost effective, but at the same time it actually might not be cost effective later on down the line if a will gets contested or it's not validly executed. There could be a lot of money at stake trying to fix those issues, or if you've planned to give money to certain people and not to others, and then your will's not validly executed, your whole plan could go down the drain. So it's very important to make sure that your will has been validly executed. Check, make sure we have any new questions. Nope. Okay. All right, so now I have put my will to probate, I've petitioned the court, and now the executor has the power to step in. And what is their job? So if your will is accepted for probate, the executor is actually going to be issued what's called letters testamentary, and those are like the keys to the castle. Those are going to give them the power to act as the executor of the estate. And then they could start handling all their responsibilities. So those responsibilities include inventorying and identifying all of the estate property. And I'm not just talking about inventorying the stuff in the person's house. I'm talking about making an inventory of all of the assets. What are the bank accounts and the investment accounts, the retirement accounts, their business interests, if they do have any real estate property, or gathering all the information about all of those assets. And that's also calling marshaling the assets, gathering all of the assets. Sometimes they also have to get property appraisals on real estate. If there's businesses involved, you might have to do some valuations of those business interests. And so that can start to become very complicated when you have all of these layers of assets involved, and they're not simple and straightforward assets. You also are responsible for paying debts and taxes, making sure that the taxes are filed. You have to get an accountant to do that. Also, in the probate process, the court's going to want to know all of the assets that need to be distributed. So you have to prepare and file accountings, which again, depending on the level and the level of complexity of the assets, is going to dictate how hard these accountings are going to be. And then, of course, you're required to distribute the estate assets later on and file the tax returns to close the estate out. And here we talk about the estate bills. What happens with those? So this is actually very important. Executors are not personally liable for the debts of the estate. The creditors I'm in New York State right now. That's where I have part of my practice. So I'll use that as an example. Creditors have 7 months to file claims against the estates for any debts that the decedent owed at the time that they died. So what I normally do is if I keep an estate open for 7 months, they have 7 months to file. And actually just this week, I was able to close one because 7 months had passed and we got no bills from any creditors. So we know that it's too late for them to file any claims against the estate. Debts must be paid from probate assets before you make any distributions to any heirs. You want to make sure that all the debts are paid. And there are certain creditors that have priorities, like funeral homes. Paying back funeral expenses is a priority. And if the estate runs out of money, then debts go unpaid. And that's unfortunately not something that's uncommon. Or even sometimes if you have a lot of debts and maybe there's not enough money to make the gifts that the will outlines, then sometimes you have to prorate the little bit of money that's left at the end to split it amongst the beneficiaries in the proportionate gifts like that were outlined in the will, if that makes sense. But if there's no money for a creditor, there's no money. The executor is not personally liable. So what about other expenses that pop up during probate? Not just debts that the decedent may have incurred and that's owed, but their probate can generate expenses and can become costly. And it's not just legal fees for hiring an attorney to take care of it. There are other costs that can add up quickly. So there are filing fees. And here in New York, there is a statutory schedule of filing fees. So basically, the bigger the estate, the bigger the filing fee is. That sometimes you have to serve notice or serve process on different players that are in the probate. So there's fees for that. Executors, you are entitled to earn a commission based on the value of the estate, and that again is set out in a schedule in the statute. But executors' commissions come out of the assets of the estate. Attorney's fees, as we've discussed, sometimes it's just as simple as hiring an attorney to get the estate through probate. But sometimes if this is a contested estate and there's someone contesting the validity of the will, then attorney's fees can become very expensive. Also, like I've talked about a couple times already, air search, searching for family members. If you have to, sometimes we have to publish things in newspapers to give people notice. Those are, again, expenses, maybe small expenses, but they add up quickly. Accountant's fees, appraisal fees, guardian ad litem. That is actually something that's I love guardian ad litem work, so I'm very fascinated by it. But a guardian ad litem is another attorney that is appointed in some special situations to represent interests of people that can't speak up for themselves. So, for instance, minors, disabled individuals, if they are receiving something from the estate, oftentimes a guardian ad litem will be appointed to represent their interests. But that attorney, it's another attorney, and that attorney is going to bill the estate and they're going to get paid for their time. So that's another cost. We'll go in the car after. And then litigation expenses. Again, a lot of times, not very often, but there are times when people they contest the will, and it can be for a number of reasons, and sometimes it actually does go to litigation, and those legal fees add up quickly. And sometimes when experts need to be involved, like medical experts, if our fight is over, did someone have capacity at the time that they signed, and we need to get doctors involved to give testimony about what the person's mental condition is, or what type of diagnosis did they have. Those doctors, those expenses add up very quickly. Another great question I get asked a lot is, how long does this process take? How long do I need to be prepared to go through probate? And the answer is it really does depend on what is involved in this estate. So if it is a simple, straightforward estate, usually it's about 7 to 9 months, because again, we have that 7-month timeline that we need to be mindful of, that we want to let that estate sit open so creditors can come forward. And probably by the time you get through all the accountings and you make all distributions and get everyone to sign off on everything, it's probably like 9 months, 7 to 9 months. But there's longer timelines for estates when you have to sell properties, so you have to wait for properties to be sold sometimes, or even businesses. If you have to sell a business, that adds a lot of timeline. So it's very easy for complicated estates to go between 12 and 24 months. But estate litigation, they could add years, months and years to the timeline. So it's definitely something that you want to avoid. No one ever wants to have to grieve the loss of a loved one and then go through a lengthy and costly court battle to fight over if the will was valid or who gets the assets. It's really a terrible thing to have to go through. So speaking of estate litigation, what are some of the complications that often pop up when we're going through the probate process? Like I've mentioned before, complicated assets are one of them. Minors also, because we can't receive assets until you're 18 years old. So if you leave money to a minor, then we have to, deposit. Sometimes we have to deposit that money in the court and let it sit there until they come of age. If someone's incapacitated, again, they don't have, maybe they have a disability where they're not able to represent their own interests, and we need to have a guardian ad litem assigned to them. Also, predeceased beneficiaries, meaning someone's in the will that has died before the decedent. So that often happens sometimes when we have couples where maybe the husband has died before the wife, and then we don't, nothing happens. Everyone goes on as normal. There's no probate that happens, and then the wife dies, and now we almost have to do a double probate. So that happens all the time. Lawsuit proceeds, maybe someone has a wrongful death suit, a medical malpractice suit. A lot of times you see situations where someone has died. A lot of times nursing homes, if people have injuries from nursing homes and then there's a lawsuit pending after their death, then they receive proceeds from that. That's a complication that has to be dealt with in the probate process, because some of those monies come through the estate. So that needs to be dealt with. Charities actually is really interesting. You always want to encourage people to make charitable gifts out of their estate, but actually when you have to go and administer them to the charities on the probate side, it actually becomes very time consuming because of all the notices that you need to give. You have to notify the attorney general because they're the ones representing the charities, and you have to also get them to sign off on the accountings. So it's always a nice, wonderful thing to give money to charity, but you have to go through a lot of extra steps to actually get the money there. Out of state property, that's something that pops up a lot. I have that happen often. And what happens with that is, I hope you know you're picking your nose on camera. Okay. So what happens is people often have to go through a process called ancillary probate. And basically that just means it's an out-of-state probate. So not only would you likely have to probate assets in the state where you died, but let's say you own a vacation home in Florida, you'd likely have to go to Florida and go through their probate process to get your Florida house. I'm reading the comments that are coming through about my daughter picking her nose. And actually, this is going to be on our website. So when she's older, I'll show it to her and let her know that she's been on the internet for years picking her nose. So I'll show it to all her friends. So yes, you'd have to go through ancillary probate to get those other out-of-state assets distributed to the people they're supposed to go to. Another issue is unknown heirs. Figuring out, are there other people out there? Sometimes people have kids they don't know about and they come out of the woodwork later on, figuring out, are you really who you say you are? That's really an interesting situation to come across. Litigation and will contests, again, when someone says, hey, I was left out of the will, I was disinherited and I shouldn't have been, mom or dad, they didn't have capacity, or even undue influence. That's another big thing. Undue influence is when someone is taking advantage of someone and basically saying, hey, make a will and leave me everything and cut out all your family members. There's someone in a relationship of confidence that's taking advantage. That's undue influence. And that's something that is another big issue that is often litigated when it comes to probate processes. Foreclosure proceedings, that's another one. If you have property that's being foreclosed on and then that it also ends up in probate. Also, if a property has a reverse mortgage on it, these are just little things that add a lot of obstacles and complications to the probate process. So I basically made probate sound terrible, and it is. It's not something that everyone enjoys going through. So why would I want to avoid probate? Well, first things first is it can become expensive. Um, you, of course, everyone always wants to minimize their financial losses, minimize the amount of money that they spend. The goal is to not spend so much money, but to be able to pass it on to your family and leave a legacy. And probate can open you up to a lot of situations where you are generating a lot of legal fees and other costs that won't get passed on to your family or to whoever you want it to go to. Um, Also, probate is your will is actually becomes public record. So there's no privacy in a probate, and sometimes that's very important and that matters to people. So if you are a private person, or maybe you have a situation in your family where you want to maybe leave more money to one child and not the other, maybe a will is not for you, because everyone's going to find out everything in the probate process. And another reason why to avoid probate is this is not seamless estate administration and distribution. There's nothing seamless about this, especially now in the COVID world that we live in. All the surrogates courts are extremely backed up, and it's taking months and months and months to get small estates through the system. So there's really nothing seamless about this. So that's another reason to want to circumvent this. Is not only expensive, it's extremely time consuming. But there are alternatives to probates. So a lot of times people will do trust planning. I love trust. Trust can be used for so many different things. And one of the main thing is to avoid probate, and also to protect your privacy. So trusts are a great tool to use. Also, beneficiary designation forms. That's something I mentioned earlier. If you have an asset that you can list a beneficiary on, I highly recommend that you do that. And that you also check those forms every couple years, because sometimes they get lost. The financial institutions, they're very far from perfect. They can lose them. Or sometimes you forget about them and there's someone that's named that you don't talk to anymore. Maybe they were your spouse and you've divorced them and you don't want them to have that money. Or maybe it's someone that has passed away. So it's definitely important to check those forms. Also, if you have assets that can be jointly titled, like bank accounts, houses, that's definitely something that's worth thinking about and might be worth taking advantage of. And also making lifetime gifts. Sometimes, giving away that whatever you want your family member to have while you're alive, instead of passing it on after you've passed on, it might be worth thinking about and strategizing to do that. So there's definitely a lot of other options. I would say that probate would always be my last resort, just because there's nothing nice about it. And it definitely could be a headache that can be avoided. But there's a lot of things to consider after someone passes away. And I know that a lot of times people grieve in many different ways. And it's important to be on top of these things because, like I said, everyone grieves in their own way. And it's very easy for the family fighting to start while people are trying to deal with the estate and they're trying to grieve the loss of the loved one. And if you know that ahead of time when you're doing your estate plan, you could definitely put together a plan that could potentially avoid that. So that's why it's really, really important to make sure you have an estate plan that's geared towards whatever your family dynamics are, because you can avoid you can avoid probate, but you can also avoid many of these other complications that I've talked about tonight. So we're getting closer to 7 o'clock and I want to be respectful of everyone's time, and someone is almost falling asleep. So I'm going to open up the floor to questions. I actually have one right now. Can lifetime gifts be monetary or material? It can be either. I had a family recently say, hey, we want to make sure there's money for the grandkids to go to school. And one of the perfect solutions for them was, let's start a 529 now. Let's not leave money to give to them later on. you guys, there's tax benefits to 529s that work for them. Sometimes people want to transfer assets like property. That's okay too. It needs to be done and documented in the right way. If we're making advances on someone's inheritance, you do need to document the right way. And sometimes there's tax implications of that. So maybe a gift tax return needs to be done, but definitely lifetime gifts can happen. They can be monetary, they can be an asset. Also, something else that you want to be mindful of is lifetime gifts with Medicaid. That could be an issue with Medicaid planning. So anytime you want to consider giving a lifetime gift, I'm going to sound really cliche here, but consult your attorney, because you want to make sure you don't solve one problem but create another one. Let's see. Yep, don't forget to add a POD to bank accounts, not just designate beneficiaries. And that's a great point, is, you know, every financial institution is different. So it's definitely something that if you want to put a beneficiary or a pay on death designation, you need to talk to your banker, talk to the bank. They will tell you what the right way for their bank to do that is. It could be different ways. I know at my bank, one bank does it one way and another does it a different way. So definitely check with them. So are there any other questions? I'm sorry that we had technical difficulties tonight. This is being recorded, like I said, so you can go back and watch the presentation, watch my daughter pick her nose. It's going to be on our website. This is our last part of our webinar series. I'm really happy for everyone that stuck with us, but I'm sad to see it end, but I am going to be doing another one probably late summer or early fall. I think I'm going to have some webinars on guardianship. We'll be talking about retirement again, estate planning, of course, and all the new Medicaid changes again, because I'm sure there'll be more updates by then. So definitely follow us on Facebook. Our website has some resources on it. That's our web resource library is always growing. Or if you want our slides, shoot me an email and I will be happy to get them to you. So if anyone has any more questions, feel free to put it in the chat now. All right, if not, I don't see any other questions. There was a lot of actually really good questions tonight. So thank you everyone for joining in, and I hope to see you on our next webinar series. Have a great evening. What would this thing